You may not act like yourself if you're hungry, but can skipping a meal cause involuntary intoxication? In People versus Garcia, we'll see whether a defendant could assert an affirmative defense of involuntary intoxication due to hypoglycemia, or low blood sugar. Hypoglycemia can occur if a diabetic person injects him or herself with insulin and then fails to eat appropriately. Steve Garcia was an insulin-dependent diabetic. One day, Garcia's wife, Johnie, told Garcia that she wanted a divorce. 3 days later, Garcia planned to eat cake at his daughter's birthday party, so Garcia injected himself with a large dose of insulin. Garcia didn't eat anything after injecting his insulin. Garcia then went shopping with Johnie. While shopping, Johnie noticed that Garcia became quiet. Johnie asked Garcia repeatedly if he needed to eat, but Garcia responded that he was fine. Later, while Johnie was driving, Garcia struck Johnie in the head with a hammer without saying anything. Johnie left the vehicle and ran away. Garcia got in the driver's seat, pursued Johnie, and eventually ran her over with the vehicle. Johnie survived, but she sustained a skull fracture and other injuries. Before his trial, Garcia informed the court that he would assert the affirmative defense of involuntary intoxication. Garcia planned to have a doctor testify that Garcia's insulin injection, combined with a lack of food after the injection, caused Garcia's hypoglycemic state. The doctor would testify that Garcia's hypoglycemic state affected Garcia's rational thought processes. Therefore, Garcia couldn't have formed the required mens rea for the crime. The trial court held that insulin-induced hypoglycemia isn't a type of involuntary intoxication. The court held that Garcia could only enter evidence about his hypoglycemia if Garcia pleaded not guilty by reason of insanity. So Garcia entered a plea of not guilty by reason of insanity. The trial court instructed the jury on the insanity defense, but the jury didn't receive instructions on involuntary intoxication. Garcia was convicted of attempted second-degree murder and first-degree assault. Garcia appealed. The Court of Appeals held that the trial court erred by preventing Garcia from asserting his affirmative defense of involuntary intoxication. The state appealed, and the Colorado Supreme Court granted cert.